Ashray versus White is a leading case explained to the maxim injuria sine denum. Which one of the following case can express injuria sine denum? Bhim Singh versus State of Jammu and Kashmir. Principle of ubi jus ibi remedium is Ashray versus White. Which one of the following is a famous case related to the exception to the application of doctrine of voluntary non-fit injuria based on case? Hanish versus Harwood. Vidyavati versus State of Rajasthan is a case relating to vicarious liability of the state. Case of Kasturilal versus State of Punjab is related to vicarious liability of a state. PO versus Steam Navigation Company versus Secretary of State for India is a leading case on vicarious liability of the state. Case of Ratilam Municipality versus Veer Chand is related to torture liability of municipal corporation. Rule of strict liability was laid down in the Ryland versus Fetcher's case. The rule of strict liability is contained in Ryland versus Fetcher. The case of Ryland versus Fetcher has laid down in the principle of strict liability of landowner. Which one of the following case does not constitute exception of Ryland versus Fetcher? Poor condition of fair. Rule regarding the principle of negligence was laid down in the leading case of Dunlop versus Stevenson. Dunlop versus Stevenson is a duty manufactured was fixed toward ultimate consumer. Which one of the following cases established civil law of tort of negligence and obliged manufacturer to have a duty of care towards their customer? Dunlop versus Stevenson. Doctrine of res ipsa loquitur was applied by Supreme Court in Municipal Corporation of Delhi versus Subhangvati. Doctrine of alternative danger was explained in Jonas versus Bosch. Borlow Hill versus Young is a famous case of nervous shock remoteness of damage. Gloucester's grammar school case explains the principle of denum sine injuria. The leading case in which test of deterrence was determining the remoteness of damage was finally established in case of D. Polymus and Furnish Whitey and Company. Case of Abharnath versus Northeastern Railway Company is about malicious prosecution. The principle of ubi jus ibi remedium was recognized in Ashray versus White. Which one of the following pairs is correctly matched in the code of strict liability means no fault liability? Supreme Court has overruled strict liability by absolute liability. The tort involved Hoots versus Picture Theatre Limited trespass. In which one of the following case House of Lords held that voluntary not fit injuria has not applicable to harm sustained by workman from negligence of his employer and not warning him of the movement of recurring danger, although the man knew and understood that he is personally run risk of injury if when the danger did occur. Smith versus Baker. The maxim injuria sine denum has been explained in which one of the following case? Ashray versus White. The verdict of Dunlop versus Stevenson was delivered in which one of the following case? Lord Atkin. Decision given by MC Mehta versus Union of India is absolute liability. The rule laid down in Ryland versus Fetcher is not applicable to when the escape is due to which measure of act of the god, when the damage is due to wrongful or malicious act of the stranger, when the escape is due to the plaintiff own fault. The rule of absolute liability was first laid down in MC Mehta versus Union of India. The principle of privity of contract was held to be not applicable to the action for tort in Winterbottom versus White. Following are the good defense to the action of tort. Volunteer non-fit injuria, vis major. In which one of the following case did Supreme Court of India gave the ruling that sovereign immunity of the state is a subject to the fundamental right? Peoples of India for Democratic Republic versus State of Bihar. In which one of the following case the basic principle of award of compensation for violation of human right has been laid down by Supreme Court in नीलावती Behra versus State of Orissa. The rule currently followed in India to determine the remoteness of damage was laid down in Overseas Tank Ship UK Limited versus Mott Dock Engine Company Limited. If it was lawful act, however ill the motive might be, defendant had a right to do it. This observation was made by the court in one of the following cases: Major of Bedford versus Cooperative versus Pickle. In which one of the following case the rule of absolute liability laid down by Supreme Court of India was followed? Indian Council of Invoro Legal Action Union versus Union of India 1996 versus Kulas Mitchell Birch versus East India Hotel Limited AIR 1997. In which case it was held that Supreme Court of that state was liable on the ground that police were acting in discharge of statutory power and power of police in keeping the property in the police Mcmahon was a sovereign power. Kasturi Lal versus State of UP. The police officer failed to observe the provisions of UP police regulation in taking care of gold seized. The injury has been committed by the employee of the state during course of employment, but the employment was a special category of sovereign power, so claim was not sustained. It was held by the Supreme Court in the case of Kasturi Rahalia Ramjan versus State of UP. In which one of the following case Supreme Court of India applied the principle of absolute liability? Charan Lal Sahu versus Union of India. Indian Council of Invoro Legal versus Union of India. MC Mehta versus State of MP. Andhra Pradesh State Road Transport Corporation versus K. Hemlata and Municipal Corporation Greater Bombay versus Lakshman Iyer are important case decided by Supreme Court in the rule of contributory negligence. Arrange the following in the chronological order: Syam Sundar versus State of Maharashtra, Puspa Bai versus Ranjit Ginning and Pressing Company, Syed Akbar versus State of Karnataka, Municipal Corporation of Delhi versus Sushila Devi. Which one of the following is a reported case of accidental urea? Dixon versus Rattle Telegram Company. Arranged in chronological order. The Secretary of State of India in Council versus Hari Bhajan, State of Rajasthan versus Vidyavati, State of Gujarat versus Menon Mohammed, Rudral Shah versus State of Bihar. Anwar Hussain versus Ajay Kumar, Vinod Kumar Santilal, Goshalia versus Girdhari Nargis Das, Sodan Singh versus New Delhi Municipal Committee, Nizam Institute versus Medical Science of Dhanaka. Which one of the following cases is a leading case of trespass ab initio? 6 Carpenter case. Holback Hotel Limited versus Scarborough Board Council is a leading case on nuisance. In which one of the following cases it has been held that Section 9 of CPC, which enable the court to try all suit of civil nature, applied conferred jurisdiction to apply the law of tort as a principle of justice, equity, and good conscience. Union Carbide Corporation versus Union of India. Union Shared Vehicle is also within the scope of Section 165 of Motor Vehicle Act. Was held in Paramanand Thakur versus Commissioner Coal Mines 1988. In which one of the following case Lord Wilberforce opined that it is necessary to consider 3 elements inherent in the claim of nervous shock: the class of person whose claim should be recognized, the proximity of such person to the incident, and the means adopted by which shock is caused. McLaughlin versus O'Brien. The Bolitho test related to medical negligence. The Bolitho test was referred in the Malya Kumar Ganguly versus Sukh Kumar Mukherjee. The egg cell skull principle was applied in Smith versus Leach, Bryan and Company. In which one of the following case Lord Wilberforce opined it is necessary to consider 3 elements inherent in the claim of nervous shock: the class of person who should claim recognized, the proximity of such person to indicate, and the means adopted by which shock is caused. Melonging versus O'Brien. In which one of the following case Supreme Court stated in the modern sense distinction between sovereign and non-sovereign power thus does not exist? N. Nagendra Rao versus N. Nagendra Rao and Company versus State of Andhra Pradesh. The rule laid down in re polymus case is that defendant shall be liable for all direct consequences of his act if he could foresee some damage of the plaintiff of his act. The lawful act does not become unlawful even if it is done with the evil motive. This was held in Mayor of Bedford Corporation versus Pickle. Supreme Court laid down in that the enterprises is engaged in the hazardous or inherent danger activity, the harm result to any one of the account of accident enterprises is strict liable to compensate all those who affect such accident. MC Mehta versus Union of India. In which one of the following case did the Supreme Court of India give ruling that sovereignty immunity of the state is subject of fundamental right? People's Serial for Democratic versus State of Bihar. The lawful act does not become unlawful even if it was done with the evil motive. This was held in the Tom Area Committee versus Prabhu Dayal. The right of the person to recover damage for nervous shock sustained while he was not present at the scene of grievous injury of family, but comes upon then The interval of the time space was the first time recognized by the House of Lords in England in Mollingly versus O'Brien, in which one of the following case court stated that the modern sense of distinction between sovereign and non-sovereign power exists in N. Nagendra Rao and Company versus State of Andhra Pradesh 1994. Which one of the following case is the authority of rescue case an exception no maxim warranty non-fit injuria? Haynes versus Harwood 1935. The right of public highway is merely the right of pass of repass, and so long as that right is not interfect with and cannot complain of what was air above or on the earth beneath. In which one of the following case the above observation is made? Novel versus Harrison. While dealing with the liability of enterprises engaged in inherent danger activity, Supreme Court laid down the rule of absolute liability in MC Mehta versus Union of India. In which one of the following cases did Supreme Court rule the principle of sovereign immunity will not apply to proceeding for award of compensation for violation of fundamental right? Naxal Beti Behra versus State of Odisha. The manufacturer liability principle was laid down in Dunlop versus Stevenson 1932. Supreme Court ruling in Sri Ram chemical case in the famous for laying down the absolute liability rule. There is no reason why compensation for non-peculiar damage should not be allowed. This was held by the House of Lords in the case of Parley versus Sneaker. The Neighbour principle was laid down in the landmark case of Dunlop versus Stevenson. Rule of absolute liability was laid down in the case of MC Mehta versus Union of India. The case of Dunlop versus Stevenson decided by House of Lords. Asway versus White is a leading case of the maxim injuria sine denum. Which one of the following is not an instant of injuria sine denum? Mogul steamship versus MG Gorge. Which one of the following case is not an instant of denum sine injuria? Which one of the following cases is not an instant of denum sine injuria? Which one are Asway versus White, Matizit versus William, Bhim Singh versus State of Jammu Kashmir? Instant of denum sine injuria. Mogul versus steamship MG George, Dixon versus router telephone, Balfour Corporation versus Pickle. Compensation can be awarded to a person who suffered the personal injury in the hand of government officer, which amounted to tortious act. This was held in the case of Urdul Shah versus State of Bihar. Which one of the following cases did the Supreme Court Exchequer explain the principle of res ipsa loquitur? Scott versus London and St. Catherine Dog Company. In the well-known case of Ryland versus Fetcher, the principle of strict liability was propounded. The principle was developed by the principle of absolute liability in the case of Supreme Court name MC Mehta versus Union of India. The rule laid down by Ryland versus Fetcher is known as strict liability rule. Dunlop versus Stevenson, negligence. Cassidy versus Daily Miner newspaper, defamation. Meriwether versus Nixon, joint tort Fisher. Bird versus Jones, false imprisonment. Mercedes Dock versus Protector, vicarious liability. Metropolitan Asylum District versus Hill, Act of Statutory Authority. Nicholas versus Marshall, Act of God. Holmes versus Matthew, inevitable accident. Mercy versus Doc Potter, Prototor, vicarious liability. Metropolitan Asylum District versus Hill, strict statutory authority. Nicholas versus Marshall, act of God. Holmes versus Mather, inevitable action. Vis major, act of God. Res ipsa loquitur, negligence. Actionable per se, trespass. Warranty non fit injuria, sentin non fit injuria. Gallic versus West Norfolk and Westpac Area Health Authority, warranty non fit injuria. Wagon versus Molundi, remoteness of damage. Asway versus White, violation of absolute right. MC Mehta versus Union of India, absolute liability. Priestley versus Flower, doctrine of common employment. Denham sign injuria, Gloucester Scrabber case, absolute liability. MC Mehta versus Union of India, injuria sign Denham, Asway versus White, inevitable accident. Stanley versus Powell. Denham sign injuria, Gloucester Grammar School case, absolute liability. MC Mehta versus Union of India, injuria sign Denham, Asway versus White, inevitable accident. Stanley versus Pauli. Violent versus Facher, strict liability. Donlock versus Stevenson, liability for negligence. Gloucester's Grammar School case, loss caused by competition in business. Ross versus fraud, compensation for pain and suffering. Injuria sign Denham, Asway versus White, Denham sign injuria, Gloucester School case, strict liability. Ryland versus Facher, defense and consent. Venom non fit injuria. Tulloch versus Stevenson, Never principle. Repolymers, remoteness of damage. MC Mehta versus Union of India, absolute liability. Lloyd versus Grace, vicarious liability. Ryland versus Facher, liability without fault. Borlaug Young, nuisance. Statues Bergman, negligence. New State London Express, defamation. Patent in the customer. Vasthana versus P. Nair versus Smriti P. Nair. Doctor's duty to maintain security. Dr. Tojuga versus Apollo Hospital Enterprises, free service. Indian Medical Association versus BP Santna, contract of personal service. K. Ranga Swami versus Jaya Vittal and other. Wagon Mound case, test of reasonable foresight. Repolymers Furnish and White Company, test of directness. Scott versus Shipshead, remote but proximate. Fadal versus Hadcourt Rivington, reasonable foreseeability. Municipal Corporation versus Shuhangwati, Supreme Court. Rooplal versus Union of India, High Court of Jammu and Kashmir. State versus Chinori Jilal, High Court of Madhya Pradesh. Rural Transport Service versus Belgium BV, High Court of Kolkata. Absolute liability. MC Mehta versus Union of India, Denham sign injuria. Gloucester Grammar School case, injuria sign Denham, Asway versus White. Inevitable accident, Stanley versus Pauli. Act of God, Hal versus Bookland and Auto Racing Company, consent. Or Act of God, Brownie versus Damon, consent. Hal versus Bookland and Auto Racing Company. Act of God, Nicholas versus Marshall. Statutory Authority, Metropolitan Asylum Board and Hill. First is Act of State, Boudon versus Denman. Repolymus and Furmish, and Company. Vicarious liability of this. Remoteness of damage. Sally versus Commissioner of Police Delhi. Vicarious liability of state. Municipal Corporation of Delhi versus Suhangvati. Duty of the plaintiff. State Wells Minerals Federation versus Golmugan Coal Company. Malice in fact. Voluntary non-fit injury. Simra Kohli versus Prabhar Manchanda. Judicial Act. Anwar Hussain versus Ajay Kumar. Act of State. Vinod Kumar Santhalal versus Kosilalal Gangadhar. Nirsingh Das Agarwal. Necessity. Olga Tellis Municipal Corporation versus Bombay. Bhim Singh versus State of Jammu Kashmir. Injurious and Municipal Corporation of Delhi versus Suhangvati. Race Absolutor. Nicholas versus Marshland. Vice Major. Mogul versus Steamship Company. MG George and Company. Denham Sign Injuria. Indian Council of Enviro Legal Action versus Union of India. Absolute liability on the enterprises carrying hazardous and inherently dangerous activity. Laren versus Fetcher. Liability for keeping dangerous thing on land. Lakshmi Rajan versus Muller Hospital Limited. Patient consent for operation did not imply consent for removing her uterus. Union of India versus United Insurance Company Limited. Contributory negligence of driver cannot be imputed on passenger. Measure of brand Ford versus Pickle. If there is no damage to the legal right, action does not lie even for malicious. Douglas versus Stevenson. Consumer can bring action against manufacturer. Callas Mittelbertschel versus East India Hotel Company. A hotel with a high charge were expected to take very high degree of care to the visitor. Dunlogin versus White and Soul. Nervous shock for the fear and the injury of the pain. Plaintiff herself was recognized. Majnu Bhatia versus New Delhi Municipal Corporation. Liability of builder toward purchaser of the flat. Municipal Corporation of Delhi versus Susila Devi. Liability of owner of a tree for injury caused by the falling. Union of India versus Lakshman. Legal duty of railway to assure reasonable safety of a railway level crossing. M.S. Grehwal versus Deep Chand Sud. Teacher duty to care toward children when they were take out picnic and fun of swimming. Denham Sign Injuria. Vishnu Dutt Board versus Higher Secondary Intermediate Education UP. Injuria Sign Denham. Bhim Singh versus State of Jammu and Kashmir. Voluntary non-fit injuria. Padmavat versus Diglinka. Rape Absolutor. Bindra Devi versus Chauhan State of HP. Plaintiff wrongdoer. Bird versus Hook Holboard. Act of God. Nicholas versus Marshland. Inevitable accident. Stanley versus Pauli. Mistake. Consolidated co-cutus. List of opportunity. Davis versus Man, apportionment of damage. Vidya Devi versus MP Road Transport Corporation, alternate danger. Syam Sundar versus State of Rajasthan, identification. Birmingham Miles versus Armstrong. Samira Kohli versus Prabha Manchanda. Label and license. Sodan Singh versus New Delhi Municipal Corporation. Necessity. Bird versus Hukon. Plaintiff a wrongdoer. Khulullah versus Hamchand. Act of God. State of Susrut versus Menan Haj Islam. Municipal law does not apply. Delhi Transport Corporation versus Kumari Lalita. Suit by Major Code. Browne versus Lewis. No right to sue as an unincorporated association. Campbell versus Pigeton. Suit against corporation. Jonas versus Bosch. Doctrine of alternate danger. Scott versus Spitz. Remoteness of damage. AK Kodwa versus State of Maharashtra. Medical negligence. Victoria Railway Commissioner versus Cotterless, nervous shock. Dunlop versus Stevenson, neighborhood rule. Smith versus Charlie Baker and Son, voluntary non-fit injury. Green Knock Corporation versus Caledonia Railway Company. Vice Major. Achutro Haribo Kodwa versus State of Maharashtra as absolutor. Res absolutor. रेस सबसॉलिक्यूटर का अच्युत्रो हरिबाऊ कोदवा वर्सेस स्टेट ऑफ महाराष्ट्र. नर्वस एक्टस इंटरवेंस. स्मिथ लिच वर्सेस ब्रेन. इंडिनो. ट्रॉली वर्सेस जीएस फैशन. लिचवन वर्सेस एगलेस स्कल रूल. लिचवन. Lynch versus Neruddin. Negligence. Grant Australian Knit Company. So Sensity non-fit injuria. Smith versus Baker. Defamation. Tollis versus J.K. Fry and Son. Eglick skill rule. Smith Litch versus Bryan Company Limited.